Chapter 8 continues our discussion about pretrial procedures, and here we're going to talk about plea bargaining and what that process looks like. So as mentioned in a previous chapter, most criminal convictions are the result of a guilty plea rather than trial, and it's somewhere around 90 to 95%. And we refer to this process as bargaining because there's usually some bargaining between both the defense and the prosecution. One of the reasons so many people take a plea bargain or engage in what's also called charge bargaining is because both parties stand to gain something from the guilty plea. The prosecutor gets to obtain a conviction, and the defense attorney can usually arrange either a lesser sentence or a lesser offense for their client. So plea bargaining is really essential to our system. If we didn't have this, think about how slow the court system already moves. And if we didn't have this process and more cases went to trial, the system would come to a halt. One thing it does do, though, is it takes the administration of justice out of the hands of judges and juries, and it essentially permits the attorneys to decide the outcome of a case without the need to go to trial. So when we define plea bargaining, there's no real agreed upon definition. Usually what this involves is the defendants pleading guilty to a lesser offense or only to some of the offense in an indictment that has multiple counts in it. And in return, they usually receive a lighter sentence. Charge bargaining refers to the prosecutor's ability to negotiate in terms of what you're actually being charged with. So this could be something where someone has been accused of a sex offense and they're able to instead plead guilty to something that's a non-sex offense. And sentence bargaining occurs when the defendant pleads guilty to a lesser sentence in exchange for a lesser sentence. So in order for a plea bargain to be accepted by the court, it needs to be intelligent and voluntary, okay? So this means that the person has to enter into it voluntarily and they must understand the consequences of doing so. It may not, however, be satisfactory to both parties. Each bargain is subject to being approved by the court and the judge has to sign off on it. The judge basically wants to determine if the defendant is willing to waive their due process rights and whether or not there's an actual factual basis for the plea. Judges generally approve of most plea bargains because it speeds up the process, we have more convictions, and it's pretty cost effective. So following the Civil War, plea bargaining became increasingly common. By the beginning of the 20th century, it was the dominant method of resolving criminal cases. So cases referring to plea agreements go all the way back to the 19th century, and plea bargaining becomes even more common in the early to mid-1900s. So we have four types of plea bargains. There's implicit plea bargaining, charge reduction bargaining, judicial plea bargaining, and sentence recommendation bargaining. Implicit plea bargains are an agreement in which you submit a guilty plea for a specific offense and it carries a conventional punishment. So this is usually what we refer to as the going rate. Okay, so there's a maximum sentence that can be imposed upon you if you go to trial, and then the going rate is sort of what do we generally actually sentence people to. Charge reduction is when the prosecutor offers to minimize the number of charges or the seriousness of the charges in exchange for a guilty plea. Judicial plea bargaining occurs when judges make offers of sentences to defendants in open court in exchange for a guilty plea. This usually occurs with petty offenses. There's also sentence recommendation bargaining. So the prosecutor proposes a specific sentence in exchange for a guilty plea. And this is an overt form of implicit plea bargaining. Judges, however, still have to approve all plea bargain agreements in all jurisdictions. So just because the prosecutor offers this to you doesn't mean that the judge is going to approve it. So why would we engage in plea bargaining? Well, it does benefit everybody in the courtroom work group, okay? It frees up the system, it saves us some money. There are, however, some arguments concerning the benefits of reaching plea agreements. So some benefits include the prosecution has an increased ability to dispose of cases. The defense benefits because they get to dispose of their case quickly as well. The court benefits because it's a prompt disposition of cases that saves judicial resources. And this can actually be fairly beneficial for the victim as well, because the victim can have the case closed quickly and the victim can avoid the trial process as well. So what are some costs associated with it? Well, criminal defendants are giving up a chance at acquittal, and they are waiving all their other due process rights. Prosecutors also tend to start the bargaining process at a high level. So just like in any other sort of haggling, you're going to start higher so that when someone bargains you down, you kind of get down to where you want it to be anyway. Some people feel that plea bargains undermine the integrity of the system and are concerned that criminals then receive more lenient sentences. The opposite extreme of this is, of course, that innocent individuals, fearing they may be found guilty in court and get a more serious sentence, may feel coerced to plead guilty. So there's several different offers the prosecutor can make, and the most common is to reduce the charges. If the defendant accepts the offer, they usually are allowed to plead guilty, or they might be offered a nolo contendere plea. You do have some constitutional rights during plea bargaining, so you are still allowed your right to counsel because charges have been filed, and your defense counsel needs to be effective. They should ensure that the client understands the consequences of the plea bargaining process. And finally, defendants also have the right to be informed of any exculpatory evidence. So any evidence that the prosecution possesses that may point to the defendant's innocence. So Brady v. U.S. is the first Supreme Court case that condones plea bargaining. In this case, the Supreme Court held that guilty pleas resulting from inducements cannot be involuntary. So an involuntary plea results when from prosecutorial coercion such as physical force. Once the agreement is reached, it needs to be approved by the court. The court is not bound by the plea, and the court will have to consider the views of the parties and the best interests of the public. If the plea agreement poses a significant risk to the public, the court does have the discretion to deny it. Prosecutors have a lot of latitude, a ton of discretion in regards to fulfilling plea bargains. After the court accepts the bargain, though, the prosecution is bound to carry out its promises that they have offered in exchange for the plea. We also want to think about, as a defendant, sure, accepting a plea is going to probably get you a lesser sentence, but there are also consequences that come along with that. So, for example, a defendant can be required to waive his right to appeal the guilty plea. Defendant can sometimes preserve certain rights, and these are known as conditional guilty pleas, but these are pretty rare. So researchers have identified 4 things that affect plea bargains. First of all, how strong is the state's case? If the state has a really strong case, they're much less likely to accept a plea. The seriousness of the offense matters too. So, prosecutors are much less likely to want to plea bargain for more serious charges. What is the defendant's prior record? And then, even though extra legal factors are not supposed to play a role here, certainly things like age, sex, attitude, marital status, employment do influence plea bargaining. So, in order for this guilty plea to be valid, the judge has to determine that the defendant does understand the plea, and it must be both intelligent and understanding. So this means the defendant has to understand the nature of the charges of which they are accused, possible sentences, and any rights he or she may be waiving by entering a guilty plea. It also needs to be voluntary. So even if a plea is understood, if it results from coercion, threats, or physical abuse, it is not considered voluntary. And finally, it has to result in facts or result from facts. You cannot plead guilty to a crime that you have not committed, although of course this probably happens. So what if you want to contest or withdraw your guilty plea? Well, reasons for contesting a guilty plea could be that the plea is a product of coercion. The prosecution doesn't hold up their end of the bargain, or whether or not law enforcement may have engaged in unconstitutional conduct. In terms of withdrawing a guilty plea, if the court refuses to accept the plea agreement, the defendant can usually withdraw the plea. If the defendant pleads guilty without plea bargaining, they can also seek to withdraw the plea. However, if the prosecution disagrees with the court's decision to refuse the plea, the defendant may not be able to withdraw it. Once the plea has been accepted by the court, it can only be withdrawn in limited circumstances. Once your sentence has been entered, the only methods to challenge a plea are an appeal or a habeas corpus review. So if a defendant moves to withdraw his or her plea and is denied, an appeal may be appropriate. If the withdrawal period has passed, the only other method of appealing a guilty plea is through a direct appeal. There are a few Supreme Court precedents that really address this, though. So that basically means we don't have a lot of guidance on how to proceed with this process. So what does some case law tell us? If you recall, case law is when cases have gone before either an appellate or generally the Supreme Court, and law has been made as a result of that. So if you allege that you're coerced, that's not sufficient for overturning a conviction. You also have to present evidence of that coercion. In North Carolina v. Alford, we get what's called an Alford plea. Entering a plea agreement to avoid the death penalty is not considered coercive. So in this case, Alford said that he agreed to a plea because he didn't want to be executed, sentenced to death. And he went before the court and said that he didn't actually commit the crime. And as we know, we're not allowed to technically plead guilty to this. But there are limited circumstances under which you can enter an Alford plea. In Bordenkircher v. Hayes, the prosecution can use additional charges to get a plea agreement. So a lot of times what will happen is a prosecutor will levy as many charges as possible against you, but you do have to at least have probable cause that the defendant committed these crimes. You can't just tack on other crimes for which you have no evidence. And that wraps up Chapter 8.